Welcome to this 5-minute briefing on the case of XL Insurance Company versus IPORS Underwriting and others, including HMRC. It's not often in the commercial court that one gets to cite Al Capone. Al Capone was, of course, ultimately liable to the US tax authorities to pay tax on his ill-gotten gains. But what would have been the position had Al Capone stolen funds belonging to another, but say to whitewash those funds, had declared them as income to the tax authorities, and then paid tax, also using those stolen funds? That essentially was the question before the court in this case. Briefly, the background involved the second defendant, who was the sole shareholder and director of a coverholder company called IPORS, who entered into a number of binding authority agreements with the claimant insurers, XL, now part of the AXA XL Insurance Group. Under the terms of those agreements, the coverholder was bound to collect premia from insureds for XL and, importantly, hold them in segregated trust accounts before their onward remission to XL. The defendants did not do this, and on XL's case misappropriated its premium funds up to around £10 million, including expending them for personal gain. After multiple injunctions and non-party disclosure orders, including for tax records of the second defendant against HMRC, XL sought to add HMRC to the proceedings on the basis of proprietary claims and unjust enrichment. HMRC opposed the application. It did so on the basis, essentially, that it was a bona fide purchaser for value without notice. It was a purchaser for value, it said, because under Section 59B of the Taxes Management Act 1970, a taxpayer shall be liable to pay the sum stated on his or her return, unless certain statutory exemptions contained in the Taxes Management Act applied, which they did not here because the time periods had expired. For example, one gets 4 years in which to claim for an overpayment of tax. HMRC essentially argued there was a statutory debt which the court could not look behind. XL submitted, and the court agreed for the purposes of this application, that that was essentially keyhole vision. Like XL, the court emphasised that the TMA provisions were concerned between the taxpayer and HMRC rather than an innocent third-party victim of fraud. It also emphasised that historic cases relating to the defence of bona fide purchaser for value, which emphasised that the defence arises by grant rather than by operation of law, and found XL's analogy of HMRC's position being akin to a squatter to be a sound one. The court also held that it could look behind the debt, particularly in the context of a manufactured liability, for the purposes of establishing the equitable defence. Once it did this, it could see that there was no underlying tax liability, and it emphasised the distinction in tax law between liability for tax and the assessment of tax. The decision is of interest not simply because of the unusual recipient of the funds. It's a rare look at the defence of bona fide purchaser for value, in particular the for value part of that defence. It's important in emphasising that it arises by grant rather than by operation of law based on historic cases, but also that the court can look behind the debt to see if true value has been given to establish the equitable defence, a defence that applies to both proprietary and unjust enrichment-based claims. It also saw it through the lens of the innocent third party victim of fraud rather than simply between HMRC and the second defendant taxpayer. So whilst HMRC had logic to their case in the express provisions of the Taxes Management Act and the sound policy behind not opening up tax returns after the statutory period for doing so had passed, there is, of course, the policy of fraud, and in this case, a manufactured debt and no underlying tax liability. This is also important in fraud cases where fraudsters are often seeking to legitimise and treat as their own funds which are not in fact their own, a process called acting out in psychiatry. Thank you.